B2 will be kind of classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hey, you guys. Anybody remember what that's from? That's a really dated reference, but you folks from Boston might remember that. What TV show was that when we were kids? Well, when some of us were kids, the Gen X of us anyway. Hey, you guys, we're gonna turn it on. We're gonna bring you the power. Anybody remember that? No, it's not Electric Company. I don't think. Maybe that is the Electric Company. You know what I was thinking of? I was thinking of Zoom, where at the end of that they say Boston, Mass. 02134. Send it to Zoom. Yeah, I think I mixed up my references. Huh. Anyway, hey, you guys. Happy Friday. Happy Friday. I think in song lyrics, and the one that came to me as soon as I started getting these droppings this morning, or filings, the defense team made was, give it to me, baby. Give it to me, baby. Remember that song? We used to sing that. That I don't remember. That sweet, that funk, sweet, funky stuff. I don't remember. Give it to me, baby. That's what it is. Clapping back hard. Defense is clapping back hard, and I love it. I love every minute of it. It's delicious. It's delightful. It's wonderful. The better bombs have set off a chain reaction. The ripple effects are enormous, and we're here for it. Yeah, wasn't that Rick James? Maybe it was. Give it to me, baby. Yeah, it was. Yeah, okay. All right. Good. You guys get me. You guys understand me. You hear me. You know where I'm coming from. Hi, Kelly Real. Thank you so much for pointing out to me that I was on that Hulu show last night. I didn't even know about it. There's a Hulu show about Delphi, and they have a screenshot of me, like right in the middle of it when they start talking about YouTubers covering the case. And Lauren is in it from Hidden True Crime. And then I am, and then some other YouTubers that I'm not familiar with, and a bunch of TikTokers. So that was a pretty cool shout out from Hulu. And I think it's also on ABC. So there you go. We're on verdict watch for Delphi. And we're on the edge of our seats. Oh, Glare Raid. Hey, guys. Thank you, Justin, for the Cash App who said that. Glare just gave you a big shout out on his show and spoke very kindly of you. And I thank you for that. Will, if you're here. And I wouldn't expect anything less. He's been nothing but a gentleman to me. So thank you. And thanks for sending your peeps over here if that's actually what happened. Yes. Glare Raid. All right. It's Friday. It's Friday. And just like every Friday, we have things and stuff to talk about. Usually they get dropped at the end of the day. So it was exciting to see these this morning in my inbox. And also, who knows what actually could happen while we're live. More things could happen. I have 5 documents. No, 1, 2, 3, 4, 5, 6 documents. 408, 409, 410, 11, 12, and 13. hot off the press because, it's the way we roll here. That's the way we roll, and that's the way we do it. All right. What should we do first? I think the first thing we're going to do, put Marcy on the spot. We're going to put Marcy on the spot because when Betterow filed one of his recent letters, I'm not even sure which one it was, 1, 2, or 3, in the Aidan Carney case, Commonwealth versus Aidan Carney case, he made public some information that I don't think any of us knew about. Maybe Aidan knew because he's a party to that case. But apparently Michael Marcy used his private email server to try and strong arm some judges into giving Chris Albert a restraining order against Aidan Carney, which was initially denied by that judge in Stoughton. Michael Marcy sent an email from his private email to a number of judges in Stoughton, including the judge who didn't grant Chris Albert that restraining order. And then suddenly, mysteriously, I think he got one. A couple of days later, it was just appeared. And contained within that email, as you may recall, was a screenshot that Marcy included because, let's face it, he's not the brightest bulb. Sorry, Mike, if you're watching, you're just not. You're just not. Don't ever become a spy. He included a screenshot of a text message from Jennifer McCabe to someone, we are not really sure who it was, that says, I know it's late, but I'm really mad that Chris didn't get it. Whoever she's speaking to, she's obviously very familiar enough with them that she texts them late at night, familiar with them enough with them that she doesn't need to explain who Chris is and what it is that Chris didn't get, because I guess it was the same day that his restraining order was denied. And then it's opening up a whole new can of worms. And it's delicious and delightful, and we're here to break it all down and talk about it. And bang, 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 bang. Let's start with document 410, and then we'll work our way into some of the other documents, because, what better way to end a Friday or start a Friday? Today, for posterity, today's Friday, November 8th, 2024. It is approaching 3 p.m. on the East Coast. And here we go. Document number 410. This is how many documents are in this file in the 400s. And this is defendant Karen Reed's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Oops, maybe you shouldn't have done that. Just a reminder that I'm not going to be able to follow the chat while I'm reading to you because I have to put this full screen for my own font issues. So if you wouldn't mind saving your questions till we get to the end. Thank you, Dawn, for becoming a new member. And thank you, I see you, gifted 5 memberships. So welcome to all the 5 new members who were randomly gifted from YouTube. You do need to opt into gifts if you'd like to be randomly selected by YouTube. And that is something you can do somehow in the chat by pushing 3 buttons somewhere and clicking on a thing that says accept gifts. Everyone settle in, buckle up, because we have some nice long reading to do today. It's going to be good. This is defending Karen Reed's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Now comes the defendant, Karen Reed. Ms. Reed is something funny, Ms. Reed, and respectfully moves this honorable court, pursuant to Massachusetts Rule of Criminal Procedure 14A2, to order the Commonwealth to produce all communications made by the District Attorney, Michael W. Marcy, from his personal email address and or cell phone that constitute material and relevant evidence in this matter, including but not limited to any communications with witnesses, i.e. statements of witnesses, and any and all ex parte communications with the court and or other judicial staff concerning this matter. I'm going to break from the document for a second to just point out the obvious that if Michael Morrissey was communicating with a number of judges in Stoughton that he CC'd on his email regarding that restraining order against Chris Albert, or I don't know what they call it there, HPO, harassment prevention order, would it strain credulity to think that he might or might not ever correspond with any other judges within his jurisdiction in Norfolk County via his private email or text message, such as maybe Judge Beverly Cannoni in this case and others? I don't think it strains credulity to think that. And I think I was waiting for this. I was waiting for this request. And we can thank our friend, one of the Killer Bees, Attorney Mark Betterow, for revealing this information. It's just the best. As grounds for this motion, recent reporting corroborated by documentary evidence demonstrates that DA Morrissey used his personal email address to communicate ex parte with Stoughton District Court personnel and judges. Footnote 1, which says, see, for example, NBC Boston, Turtle Boy's defense claims DA lied about evidence, improperly used personal email, and then they so kindly include the link for Judge Cannoni. In the publicly available email sent by DA Morrissey to Justice Stacey Fortes, copying Massachusetts Trial Court Administrator Thomas Ambrosino, Justice Daniel O'Malley, who presided over Ms. Reed's case while it was pending in the district court, Philip McHugh, Deputy Court Administrator, and First Assistant District Attorney Lynn Beland. Well, I think she's since flown the coop, as it were. Quack, quack. Lynn Beland, and it says Ms. Beland, or First Assistant Ms. Beland, or Beland, I don't know how she pronounces it. DA Morrissey attached what appears to be a text message or iMessage sent to a member of the prosecution by a witness in this matter that constitutes a discoverable statement under Massachusetts Rule 14. Footnote number 2. Copy of DA Morrissey's email is attached here too as Exhibit 1. This email, and presumably a number of other communications that are material and relevant to Ms. Reed's case or constitute statements of witnesses, are in the possession, custody, and control of the Commonwealth insofar as DA Morrissey is the district attorney of Norfolk County. Ms. Beland is his first assistant, and both are members of the Commonwealth for the purposes of Rule 14. Accordingly, Ms. Reed respectfully moves this honorable court to order the Commonwealth to produce any and all communications by DA Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications with the court and or judicial staff regarding this case. An affidavit of counsel is attached here too and is incorporated herein by reference. I just want to point out that other judicial staff that could be included or may not have any communications privately from DA Morrissey could be perhaps the court clerk, Jim, who, is Judge Cannoni's court clerk. What is his name again? Remind me of his last name. Jim Mick something. Could be, if Lieutenant Fanning was in charge of the jury, could be communications with Fanning. Maybe such as like what's going on inside the jury room. I don't know. McDermott. Thank you, John Monagle. Jim McDermott. Jim, the OUI guy. Yeah, that came out recently too. A lot of drunk drivers that kill people involved in this case, or seriously injure or maim people, one of whom is not Karen Reed. But it's interesting nonetheless. Where was I? An affidavit of counsel is attached here too and incorporated herein by reference. Factual background. On October 17th of 2024, Attorney Mark A. Betterow, Attorney Betterow, filed a letter with this court directed to Norfolk County Special District Attorney and former Judge Robert Cosgrove. He is the one who is now, Robert Cosgrove is now the special prosecutor or special ADA or that's been filling in or sitting in or has replaced Ken Mello Yellow, who seems to have gone MIA. Does anybody have proof of life on Ken Mello? There's never been, I don't think, that I've ever seen more special assistant district attorneys appointed in a series of cases that are all related due to conflict. So they've got special ADA Mello, who was appointed because apparently Norfolk District Attorney's Office couldn't prosecute Aiden Carney because of a conflict. And now he's sort of MIA. And they brought in this guy Cosgrove, who used to be a judge. And they've also gone outside and hired Hank Brennan to prosecute Karen Reed, not for conflict of interest, but because apparently it's a hot potato and nobody in the Norfolk County DA's office even wants to retry Karen Reed. So they had to go outside, get a hired gun to come in at the bargain basement rate of $250 an hour with a cap of 75 grand, which I'm sure has already gone based on all the recent motions that we've been over, filed by Hank Brennan. This is just very uncommon, let's just say. It doesn't happen very often. And the fact that these are only 3 of the examples that I'm talking about, and I'm sure there are more special prosecutors that have been assigned in this case. It's like we're getting into Fonnie Willis territory here, guys. In his letter, Mr. Betterow detailed communications between Ms. Jennifer McCabe and a yet unknown member of law enforcement, revealing that DA Morrissey had communicated on an ex parte basis with members of the Massachusetts Trial Court and Stoughton District Court, including the Honorable O'Malley presiding. Footnote 3 says Betterow's letter is attached. And 4 says, prior to her indictment, Ms. Reed's case was pending in Stoughton District Court as Commonwealth v. Karen Reed with a different docket number with Honorable O'Malley presiding. Then when they, upgraded the charges to murder in June of 2022, that lobbed it over into Norfolk Superior in front of the judge we now currently have, who has now had a special order that she's going to remain on the case. Maybe. And I say maybe because if in this discovery response, any emails are discovered between the DA and the judge that are ex parte related to this case from his private email, it's going to be a problem. It's going to be a problem that could disqualify her from retrying this case. I have no idea if they exist, but it wouldn't strain credulity to think that he similarly, corresponds with other judges this way. It's like he's the personal, is he the personal counsel on speed dial to the Albert family and the McCabe family? And if so, these cases are intertwined. Many of the same witnesses in the Karen Reed case and potential third-party culprits are victims, allegedly, in Aiden Carney's cases. So there's that. In his email, which Mr. Morrissey sent from his personal email address while copying First Assistant Beeland's office official Massachusetts government email address, DA Morrissey detailed the fact that Mr. Chris Albert, another witness in this matter, had sought an ex parte harassment prevention order against Mr. Carney, which was denied by Judge O'Malley. So that harassment prevention order is what many of us would refer to as a restraining order. Despite the fact that these hearings are public, DA Morrissey accused a member of the Stoughton District Court staff of leaking information about the harassment prevention order proceedings to Mr. Carney. DA Morrissey alleged that Mr. Albert's affidavit in support of his HPO was improperly disseminated to a third party, i.e. the defendant in that harassment prevention order. So what they're saying here is that in order to get a restraining order against someone, if you're the one looking for the restraining order, you have to fill out an affidavit that says, here's why I need it, here's why I'm afraid, here's what they've been doing to harass me, and so I want you to grant this order. Apparently, Aidan Carney got a hold of this affidavit, and you may recall from prior things that we read in the Better letters, they accuse one of the women working in Stoughton District Court of releasing this information to Aidan Carney, despite the fact that it's public. The proceedings are public, and the file is public. And I think they actually fired her over that. Despite the fact that these hearings are public, DA Marcy accused a member of the Stoughton District Court staff of leaking information about that harassment prevention order to Mr. Carney. DA Marcy alleged that Albert's affidavit was, as we just said, improperly disseminated to a third party. DA Marcy appended a text message or iMessage to his email from Ms. McCabe, which reads, quote, I know it's late, but I am horrified that Chris Albert didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to Mr. Carney. Footnote 5 says, at this time, it is not known with certainty whom the recipient of this message was. The defense would note that this text message was not included in the previously produced text messages between Ms. McCabe and Trooper Michael Proctor, deposited with the Norfolk Superior Court's clerk's office by attorney Kevin Reddington on February 15th of 2024. This says two things. On the one hand, we're not going to accuse you of failing to turn over something that actually was included that actually was contained within the text messages between Jen McCabe and Michael Proctor. We're not going to exactly accuse you of that. But if it wasn't made to Michael Proctor, who was it made to? Did she have Michael Marcy's phone number? Personal phone? On speed dial? Did she text it directly to Marcy? DA Marcy directly referenced this matter, which he referred to as the Commonwealth versus Reed murder case, R-E-E-D, in his email. Anybody want to guess why he spelled Reed wrong? I'm just going to guess that just in case, because you know damn well he knows how to spell Reed. I don't think it was spell correct. I think it was in case anybody happened to search through his email for Reed, R-E-A-D, it wouldn't come up. It's a guess. Maybe it was spell check. I don't know. He further notes in his email that the Commonwealth was informed by Mr. Albert and others that Mr. Carney had been provided with the HPO affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contacted either the Norfolk County District Attorney's Office, the MSP, or another police department involved in this case. Well, that's going to be discoverable too. Regardless, the Commonwealth has vis-a-vis DA Marcy acknowledged that it is in receipt of statements from a number of witnesses in this matter, which were apparently withheld from the defense. Shocked? Appalled? Are you in shock and horror that they were withheld from the defense? Trouble ahead, trouble behind. He says that in his own email, that he's received statements from a number of witnesses in this matter. We're going to look at his email after this. We've already looked at it once, but you can never look at something too many times when it's fun. Without citing any specific statute, rule, or regulation, DA Marcy opined that the receipt of an affidavit in support of an HPO by a defendant in that very HPO proceeding was, quote, completely unacceptable and must be resolved immediately, noting that the improperly disseminated court material unsolicited to a third party which is continuing to cause harm and damage to a witness in an ongoing homicide prosecution, must be a violation of court procedures, court policies, or a potential violation of law. DA Marcy concluded his email by stating, I understand that you have to do an investigation and that may take time, but you also have to provide us with some evidence and assurance that you have taken action so we can safely continue to use the clerk's office of the Stoughton District Court. Legal standard. The Due Process Clause of the Federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only, quote, tend to diminish a defendant's culpability, end quote. A prosecutor's duty to disclose extends to all facts within the possession, custody, or control of a member of the prosecution team. The prosecution team generally is understood to include prosecutors and relevant law enforcement personnel. Put differently, a prosecutor's obligations extend to information in possession of a person who has participated in the investigation or evaluation of the case and has reported to the prosecutor's office concerning the case. There are some cases here which actually include state police crime lab chemists within the prosecution team and victim and witness advocates within the prosecution team and the medical examiner within the prosecution team. On request, prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. Under Massachusetts Rule of Criminal Procedure 14A2, a statement is defined as a writing made by a person having precipient knowledge of relevant facts and which contains such facts signed or otherwise adopted or approved by such person, or a stenographic, mechanical, electrical, or other recording or transcription thereof, which is a substantially verbatim recital of an oral declaration and which is recorded contemporaneously with the making of the oral declaration. Any victim or witness statements in the possession, custody, or control of an advocate are subject to discovery order. The prosecutor must determine whether the advocate's notes contain such statements. That was a different, citing another case. Prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice, and the drastic remedy of dismissal of charges may become an appropriate remedy. Argument. DA Morrissey's communications are within the possession, custody, and control of the Commonwealth and constitute material and relevant evidence or statements of witnesses pursuant to the provisions of Massachusetts Rule of Criminal Procedure 14. Yeah, somebody said, I love that the scan is crooked. Makes sense, right? It is axiomatic that a district attorney himself is a member of the Commonwealth or the prosecution for the purposes of Rule 14 analysis. The use of a personal cell phone or email address does not shield otherwise discoverable information from production. Here's a case directly on point from 2024 that says, from Massachusetts, text messages sent or received by state employees on personal cell phones that pertain to official business are public records. Nailed it. There's always a case. There's always a case. But you know what's great? There's always a case, but there's not always a case that's so current or recent. This is a case from this year. Massachusetts Rule of Criminal Procedure 14A2 provides that the defendant may move, and following its filing of the Certificate of Compliance, the Commonwealth may move for discovery of other material and relevant evidence not required by Subdivision A1 within the time allowed by 13D1. Rule 14 requires as mandatory discovery that the Commonwealth disclose material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or scientific tests or experiments, and statements of persons the party intends to call as witnesses. The work product rule exempts from discovery those portions of records, reports, correspondence, memoranda, or other internal documents which are only the legal research, opinions, theories, or conclusions of the adverse party or his attorney and legal staff. Rule 14 preserves the core of the work product doctrine by sheltering the mental processes of the attorney. The doctrine encompasses prosecutors' notes made in preparation for trial, including notes from interviews with witnesses. And there's a bunch of cases in that next paragraph. There is no indication that anything in the publicly available email sent by DA Morrissey from his personal email address could reasonably be construed as constituting work product under Rule 14. On the other hand, DA Morrissey's email includes a message from Ms. McCabe that would constitute a statement under Rule 14 and which should be disclosed to the defense. As noted in the reporter's notes to the rule, quote, prior informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. On this view, if the police have taken a statement of a witness who will testify, it should be discoverable to the defense. You know what's funny about that? None of the witness statements were signed. They just weren't. Even though the reporter's notes to this Rule 14 kind of indicate that they're supposed to be. As yet noted above, DA Morrissey appended to his email a message sent by Jennifer McCabe to a yet unknown member of the prosecution team that reads, quote, I know it's late, but I'm horrified that Chris didn't get it, and I'm even more disgusted that for the second time, someone from the court leaked it right away to Mr. Carney. See Exhibit 1. Since this message was not included in the communications received by the defense in response to a Rule 17 motion directed to communications between Ms. McCabe and Trooper Michael Procta, it was presumably received by another member of the prosecution team. Given the tone and informal nature of the message, apparently sent late in the evening, it seems unlikely that this was the first occasion on which Ms. McCabe contacted this person. The communication further suggests some level of coordination conspiracy between Mr. Albert, Ms. McCabe, and members of the Commonwealth in their decisions to seek harassment prevention orders against Mr. Carney. As also noted in his email, DA Michael Morrissey told the recipients that the Commonwealth was informed by Mr. Albert and others. Oh, I didn't get to finish redlining this, and you know that's one of my favorite things to do. So let me just get my red pen ready here. Mr. Albert and others. That Mr. Carney had been provided with the harassment prevention order affidavit filed by Mr. Albert, indicating that a number of witnesses in this matter had contacted the prosecution team. Setting aside whether these communications constitute statements under Rule 14, subject to mandatory discovery, on request, prosecutors also must disclose material and relevant statements of persons within their possession, custody, or control. Ms. Reed herein requests that any communications constituting statements of persons the Commonwealth intends to call as witnesses at the second trial in this matter be produced. A prosecutor is expected to actively seek out any exculpatory evidence held by the Commonwealth or another member of the prosecution team. That's the Graham case that Judge Cannoni loves to refer to when she's questioning or peppering with questions and interrupting the flow of their arguments of the specifically non-Massachusetts attorneys, Ms. Little. I remember her saying, and Ms. Little, how does that relate to Graham and McFarland? How does that relate to Graham and McFarland? No relation, by the way, to Elizabeth or Eliza Little, who's part of the defense team here. A prosecutor's obligation to disclose exculpatory material is just that, an obligation, not a decision. As noted above, informal statements not intended for court are not only often admissible at trial, but often more probative than formal signed statements in anticipation of litigation. Furthermore, though a defendant need not make such a request to mandate disclosure, right? They're supposed to turn it over whether they ask for it or not. Ms. Reed requests that any material exculpatory evidence contained in DA Morrissey's private communications concerning her case, which is a matter of public interest, to be disclosed. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only to tend to diminish a defendant's culpability. So this is automatic disclosure. And we know that Michael Morrissey knows about automatic disclosure because we went over this in one of the more recent streams, and also all the way back when the TUI materials were released to both sides, because the letters from Michael Morrissey to, at that time, I think he was the special U.S. attorney for Massachusetts, as they were ramping up in desperation to try and find out what exactly the DOJ was investigating with regard to Michael Morrissey and his office and his case and whatever cases he was covering. He repeatedly used his Brady obligation as a reason for why he so desperately needed to know what the FBI and the federal grand jury was investigating, because he said in all of his letters, I have an ongoing obligation to turn all this stuff over. As you know, under Brady, I am obligated to turn all this stuff over. So I need to know what it is that you have, what it is that you're investigating. He knows all about his automatic disclosure obligations. Point 2, DA Morrissey's ex parte statements regarding this case are improper, not protected by any privilege, and should be produced to the defense such that it may determine if extraneous influence was asserted over members of the trial court or any other party related to this case. Well, that's exactly what they want to know. Was Morrissey strong-arming Judge Cannone? Were Alberts and or McCabe's trying to strong-arm Morrissey? What the duck is going on here? Any ex parte communication with a trial judge is contrary to the basic values of fairness governing litigation under our adversary system. DA Morrissey's ex parte communication with trial court justices, including the very judge who presided over Ms. Reed's case while it was pending in the district court, and his demand, because it was a demand, for evidence and assurances that action had been taken by the Stoughton District Court is extremely concerning and raises concerns about the integrity of this prosecution, as if they weren't already raised. I love how David Unetti is able to temper his true feelings and outrage when he writes. It's just, it's a work of art, because my snark would be much more evident, as is Bettero's in some of his writings. And I give Attorney Unetti, or Misty Unetti, or Miss T Unetti, so much credit for holding back on the much deserved snark here, because this is outrageous. You should be outraged. The judiciary's independence from other branches of government and from outside influences and extraneous concerns has been one of the cornerstones of our constitutional democracy, intended to ensure that judges will be free to decide cases on the law and the facts as best their judgment dictates, without fear or favor. And I mean, how could we not file anything without quoting John Adams? The writings of John Adams, preceding the drafting and adoption of the Massachusetts Constitution, developed and articulated the essential linkage between judicial independence and impartial decision-making. Judges' minds should not be distracted with jarring interests. They should not be dependent upon any man or body of men. To these ends, they should hold estates for life in their offices, or in other words, their commissions should be during good behavior and their salaries ascertained and established by law. That is citing Thoughts on Government from 1776 in 4 works of John Adams. Since D.A. Morrissey cannot in good faith assert any work product or other privilege with respect to his ex parte communications about this matter, Ms. Reed respectfully requests that this honorable court order production of all such communications. Citing several more cases on point. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court orders the Commonwealth to produce any and all communications by D.A. Morrissey that are discoverable under Rule 14, as well as any and all ex parte communications about or concerning this case. Bomb, 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 bomb. XOXO. David Yannetti. Oh, let's go to the exhibits. And Alan Jackson, Pro Hoc Vice. And David Yannetti signs an affidavit of service here that he served it on the other side, which is Hank Brennan. Wait. Maybe the exhibits are with the other thing. Okay. Moving on. Let's check the chat for a second before we move on to our next document. This is a fun way to spend a Friday. It is for me. I hope you enjoyed as much as I do. RB, thank you for your super sticker. Thank you, Willing. Thank you so much for your super sticker. Lori Jean, welcome to membership. Thanks for joining. I think you're going to like it here. Sue Esponte. Oh, Sue Esponte. Do I love that? I love that. Thanks to the 5 on top of Yannetti, all covered with sleeves. I subpoenaed meatball. Give it all to us, please. All together now. That's awesome. Thank you. All right, Dave Matthews Band 22 coming in with the super sticker. So damn lucky, aren't we? So damn lucky to be together on this Friday. Thank you for tuning in, DMB 22. If you know, you know. Kimberly Morgan became a member too, and welcome. Hi, Mandy Stone. I'm so nervous about the Richard Allen verdict in South Africa. We only got mainstream Murdia version, so I thought he was guilty. I was so wrong, hoping justice will prevail. Thank you, Mandy. Thank you for that, for tuning in from South Africa. The world is watching that case too, right? That case and this case. Thank you. Tara in Boston with $100 super chat. What? Everybody give it up for Tara Boston. Woohoo, Tara. I can't wait to see Meatball Morrissey in handcuffs and an orange jumpsuit. Not soon enough. Justice for John O'Keefe and Carrie. Thank you, Tara. Everybody go up there and give Tara some props. It's very generous of you, and I appreciate you so very much for always being such a great, generous contributor to this channel with your comments and your insight and your support. I appreciate you more than you know. Ad Astra, thanks for the 5. Do you think Bev was pulled from the other 2 cases to prevent issues if she is involved with Morrissey's emails? That's an interesting thought. It's an interesting thought. I haven't really thought about it. But like I said yesterday, I think that keeping her on this case for now, it was the right decision because she had already tried the case and she's fully familiar with all of the pretrial proceedings and rulings and motions and questions that have already been answered. And so that was the right call. I think perhaps that has to also to do with her, because wasn't she transferred to civil court at some point? So perhaps the Karen Reed case is the only criminal case that she's still on. And I don't know the answer to that, so I'm not sure. But that's an interesting thought. She was pulled, for those of you who don't know, she was pulled from Brian Walsh's case and the Ingolf Turk case. Both of those cases were specially assigned to other judges, each one a different judge. And she was specially assigned to hear the Karen Reed retrial. Both of those other cases, Brian Walsh and Ingolf Turk, although they involve some of the same players in this case, like Proctor et al., are pre-trial. So I don't know when the trial dates for those are scheduled. I think there's enough time for a new judge to get up to speed. So that's an interesting question. Suze, do you expect all motions filed this week to be heard in the hearing next Wednesday morning? Please let me know if you want the Zoom link. As always, I would love the Zoom link. That would be great. Thank you for that. But I'm sure it'll be televised and we'll see who's got the better feed. But absolutely, yeah, thank you for that. I anticipate one of these motions, they're just asking the judge to rule on without a hearing. But knowing Bev, I'm pretty sure she's probably going to put everything on. She's going to want to hear everything on Wednesday. So Mr. Brennan better be prepared. Better be prepared to argue why he doesn't think that he should have to give up Michael Marcy's private emails. Sumo, thanks for the 5. Can Bev dismiss the charges for Brady violations without any of these things ever being released? And we see maybe if there's anything from her. Well, she can. But the district attorney could dismiss the charges at any time. Then I don't think they're going to. The judge, we saw that in, where we saw that? We saw that in the Alec Baldwin case. When that judge over there in New Mexico, for what she considered to be an egregious Brady violation, dismissed the charges in open court. She just did it. And that prosecutor, Carrie Marcy, put herself on the stand to question herself about why she didn't turn the stuff over. It was wild. I mean, of course, if it turns out that there are emails between the two that were improper, another motion could be made to dismiss the charges, dismiss the case outright. We're going to have to stay tuned, Sumo, because I have a feeling we're going to be here for a very long time talking about this case. Unfortunate for the Reed family, of course, but thank God that she's got so much support from all of you. The Goodmans are here and they gifted a membership. Hello, Goodmans. Thanks for tuning in. Thank you, of Bereen, for becoming a new member. I think the word you're looking for is lapdog. Perhaps. That's a good one. Thanks, Tracy. Furious. Is it fair to say that Bev would recuse herself for the motion if she knows she had ever received communications like that from Marcy? What's fair? What is fair inside of Norfolk Superior? I think that's a very subjective term. Would she do it? Or would she just deny the motion? Stay tuned. And Laura became a new member. Thank you, Laura. All right, let's get back to Misty and Eddie's affidavits supporting. Well, and basically what it says is nothing more than I say that everything that I've just told you in my motion is true. I've been an attorney since December of 1989. Oh, he's older than I am. I had no idea. And he was retained on January 29th of 2022. So he says that he was retained the exact same day that Officer O'Keefe's body was found. And that is the smart thing. That is what smart people do. They get an attorney right away when they have reason to believe that Popo's going to come knocking, as they did that same day in Dighton. Proctor and Buchanan showed up, took her phone in her car. So that's a smart thing. That doesn't show consciousness of guilt. That is what smart people do. Never talk to the police without a lawyer. I don't give out legal advice on this channel, but I will strongly suggest to you that you do not ever speak to the police without a lawyer. Look at what's going on with Richard Allen. Let that be a lesson. So that is just the affidavit in support. Next comes the motion about the sidebars. Remember how in this trial, everything, all the objections were argued at sidebar. Remember that? All the objections were argued at sidebar. They were not allowed to even state grounds for their objections when they objected, which I thought was quite bizarre, because how can they ever argue in the future or preserve the appellate record if the grounds for objections are not stated? It was weird. It was weird. And that's what they did. And apparently, all those sidebar conferences were impounded or sealed by agreement of the parties. And so now the argument is going to be, you need to unseal those sidebars because we need to argue things in our next motions in lemonade that were discussed during the sidebars. So let's take a look. This is entitled, this is document number 408. Defendant Karen Reed's motion for relief from April 14th, 2024 order to impound sidebar conferences. Now comes the defendant Karen Reed and respectfully moves this honorable court to release the transcripts of sidebar conferences that occurred prior to and during the trial in this matter from the court's April 14th, 2024 order of impoundment. I'm parched. As grounds for this motion, Ms. Reed states that evidentiary issues that arose during the first trial will be the subject of forthcoming motions in lemonade that will be filed prior to the commencement of the second trial, which is currently scheduled to begin on January 27th of 2025. Yes, they're motions in lemonade, but I call them motions in lemonade because that's what the closed captions did during this trial. And so we've adopted it. We like it. Without the ability to review the transcripts of those sidebar conferences and the rationale for the court's rulings, Ms. Reed will be unable to properly prepare for trial. Ms. Reed further states that that good cause no longer exists for impoundment of the sidebar conferences that occurred during the first trial. See Rule 7B. Ms. Reed further relies on the attached affidavit of counsel, which is incorporated herein by reference. I just want to point out that this motion is so obvious that it's sad that they even have to make this motion to give the judge all the reasons of why they should be unimpounded. But here we are again. And unfortunately, this is something they have to do because it's not so obvious. But as an attorney, this is like just obvious. Everyone should just stipulate to it because they're both going to need to have access to what was discussed at sidebar and why the judge ruled the way she did on certain objections. For example, a huge one to me is the inverted video and the objection that was made to that and what was discussed at sidebar regarding that and why the judge ruled to allow it in. I want to know. I want to know what was discussed during sidebar. That's just one of the examples I can think of. I'm sure as we go through this, I'll think of some more. If you think of any more, put them in the chat. Somebody said, couldn't Marcy just delete these emails and lie of their existence? How would anyone know? Well, the recipients would know, for one thing. And I don't think, I'm sorry, I'm not highlighting this. It's just on my phone. It's Gambrella Girl. Thanks for this question. I don't think, well, I mean, who knows, that there are any judges out there who are going to risk their livelihood for Marcy. But you don't know. I mean, Marcy's risking his livelihood for God knows who. Look at what Proctor did. Proctor blew his life up for certain people connected with this case. And I don't get it. I don't get it. Somebody's like, I missed I need a quick update. I missed the beginning of the stream. Like, you're kidding, right, Hannah? That's a joke. Do you want to send me some emails and have me forward them to someone else on your behalf? Would you like me to do that too? Just call me. Just call me Madam Secretary. All right. Kid issues. Okay. Background. On April 10th, 2024, the Commonwealth filed its motion in lemonade for appointment of court stenographer, ongoing order to impound all sidebar conferences and impoundment of juror names during trial. Attached here too is Exhibit 1. The Commonwealth sought impoundment of the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable until a verdict is returned. And that until a verdict is returned is in bold font. I'm just trying to remember. I don't think I really remember any sidebar discussions during pretrial proceedings because we did a lot of those hearings together. But I'm not absolutely positive. There may have been when there were a lot of people in the courtroom. Some things discussed sidebar, but I can't off the top of my head remember what they were about. The Commonwealth's rationale was that the publication of matters discussed at sidebar, including jurors' names, information, and potentially sensitive responses to inquiry while trials ongoing could prejudice the parties and expose jurors to extraneous matters. In its motion, the Commonwealth noted that after a verdict is returned, the potential prejudice to the parties will be greatly lessened and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. So then they go on to talk about Rule 7 and that any judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold documents from the public is shown. And then to determine whether good cause is shown, there's a test. The judge needs to balance the rights of the parties based on the particular facts of each case. And in making a good cause determination, a judge must balance the interests of publicity and a defendant's right to a fair trial. Can you hold on? Because my daughter will not check YouTube to see that I'm live when she's peppering me with text messages. So hang on for 1 second. I will be right back with you. Talk amongst yourselves for a second. Okay. It's also getting a little hot in here. It's getting a little hot in here. It's like 70. I'm on sidebar with a kid. Mommy's never get a minute to themselves. It's like 70 degrees here today. It's crazy. It does not feel like November. I mean, Thanksgiving is almost here. What the duck? That's okay, though. It's better than being freezing cold. I'll take it. I'll allow it. I'll allow it. Oh my gosh, that's a great one. That is a great one. How long before somebody changes their handle to AJ's beard? That's great. I love it. I'll allow it. I'll allow it. Okay, so there needs to be good cause shown. So they have to balance the rights of the parties with the public being able to know what's in those impounded sidebars or documents. And they need to balance the interest of the public with the defendant's right to a fair trial. See where he's going with this? Once entered, an impoundment order remains an interlocutory order subject to the continued existence of good cause. That means that it is subject to change, that it's just something that is temporary until such times as circumstances change, like now, is what they're saying. Things can't be impounded forever. Sort of like in the beginning when she impounded the jurors' names for 10 days until Juror Doe made a motion to have them impounded further. And then she said, I'm going to extend it indefinitely, but at some point, they're going to have to become public. And here's the key to this. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. And in this case, that was the Commonwealth. The Commonwealth was the party that asked that the sidebars be impounded. The defense agreed to it. And here we are. And the first prong of their argument is because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impounded materials should be released at a minimum to the parties. So they go on to say, talk about the jury list, which we just did, that the court ordered impoundment of the juror list on July 8th. But the order of impoundment related to the sidebars was entered by agreement on April 14th of 2024. And I went back and I tried to look for the order, and there is no order. She just literally hand wrote on the motion, agreed by consent, and then initialed it and put a date. I mean, no written order. So that's why I couldn't find it. So they go on to talk about the juror list, that the court issued an order impounding the juror list on July 8th. And then when Juror Doe filed an emergency motion on July 18th, the court ordered the indefinite extension of the sealing the identities of the deliberating jurors. And the defense goes on to say, we're not going to challenge that part of the jurors' identities. We're not, keep it impounded. We don't care about that. And then they go on to say, evidentiary issues, or we agree that the jurors' identity should still be impounded. Evidentiary issues raised during the first trial in this matter were discussed at sidebar. To the extent that the Commonwealth was concerned that the release of sidebar conference transcripts during the pendency of the first trial could expose jurors to extraneous matters, since the trial has concluded, that issue is now moot. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parts of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. With regard to the discussions of evidentiary issues at sidebar, however, good cause no longer exists for impoundment. Good cause instead now exists for the release of those sidebar conferences insofar as Ms. Reed's right to a fair trial is implicated in her ability to draft and litigate through motions in limine evidentiary issues that arose prior to and during the course of the trial. The issue of raising and being able to properly litigate evidentiary issues by reviewing in detail transcripts of sidebar conference discussions is non-frivolous and constitute a proper challenge to the continued validity of the prior order of impoundment. And that is quoting direct language using the keywords in a case from 1994, Pansy v. Stroudsburg. In balancing the public's right to inspect the documents against a defendant's rights guaranteed by the Sixth Amendment to a fair trial, a court may consider a variety of factors. These may include whether the information's already been disclosed, the nature of the documents under impoundment, or whether there are alternatives to withholding public access, such as change of venue. There are, at this juncture, few aspects of this case that have not been explored in depth publicly. In fact, in its determination to consider the order of impoundment regarding juror identities, the court noted that this case has garnered significant and divisive attention in Massachusetts and across the nation. I would even argue across the world. In other words, virtually every issue in the case, especially following a completed trial, has already been disclosed. This factor weighs in favor of ending the previous order of impoundment. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein only seeks release of sidebar conferences, not the identities of the jurors subject to previous orders. To the extent deliberating jurors could have been exposed to the extraneous information the Commonwealth referenced in its April 10th motion, that concern ended with the jurors' service. Additionally, there are few, if any, privacy interests implicated by evidentiary discussions at sidebar. The extent of the community interest also weighs in favor of the release of the sidebar conferences from order of impoundment, even while acknowledging the court's duty to minimize the effects of prejudicial pretrial publicity. Though Ms. Reed does not bear the burden of establishing that good cause no longer exists for the order of impoundment to remain in effect and need not establish a material change in circumstances, she would be remiss not to mention that any good cause that did exist during the trial for this order of impoundment no longer does. The factors the court must consider in determining whether to continue its previous order of impoundment all instead suggest that the referenced sidebar conferences should be released at a minimum to the parties currently preparing for a second trial. Conclusion: for these reasons, Ms. Reed respectfully requests that this honorable court releases any sidebar conferences that occurred during trial and any pre-trial sidebar conferences dealing with the evidentiary issues from its prior order of impoundment. Ms. Reed further requests that this honorable court rule on this motion administratively without the need for a hearing. So here's what this is where they say, we don't even need a hearing. We don't even think that there should be any opposition to this. This is so basic and so obvious that the court should just grant it. XOXO, David Yannetti, Exhibit 1. And this is the original motion that was made by the Commonwealth on April 10th of 2024. This was pre-trial. And here's her order right here, scribbled on the side in the margin. 4/12/24, allowed by agreement. She signed her name. And I don't know what it says underneath that. Attention, Jim. I'm not sure. ATT Jim. I'm not sure. Or maybe Jim signed it on her behalf. I don't even know. This was the original motion by the Commonwealth. I don't even know if we ever went over this initially, but here it is. They wanted the court to appoint a stenographer for the trial and deem impounded the names of all jurors, all sidebar discussions, including sidebar discussions during pretrial proceedings, and that sidebar discussions and juror names be unavailable to the public until a verdict is returned. Well, we don't know. A verdict might have happened, but it's on appeal right now. But in any event, the trial is over, and without having transcripts of what was argued and what the rulings were during those sidebar discussions regarding pretrial motions in lemonade, and pretrial hearings and objections made during trial with regard to evidence that was either not let in or let in over objection, they cannot possibly prepare for the retrial. It's just, this is so obvious that there's no reason why she shouldn't automatically grant it, but we're back in the twilight zone here. And then he goes on to say, Lally, Norfolk Superior Court uses traditional courtroom stenographers and, for the record, FTR equipment to record courtroom proceedings. I guess the FTR equipment is the thing that Madam Court Reporter was talking into that looked like an athletic cup. If you haven't seen Auntie Deb's videos, you gotta go watch them. They're hilarious. It appears FTR recordings may be available less than 24 hours after the courtroom event without any opportunity for a party to have notice or an opportunity to object, or for a judge to consider a request for access to a sidebar discussion. It appears that anyone can create an account and a request for access to a particular recording, which will be reviewed by a clerk who authorizes access unless there's an order of impoundment or other judicial process prohibiting access. The absence of an order of impoundment of all sidebar discussions could result in those discussions being publicly disseminated during trial and potentially prejudicing the parties. Yes, people like me would get a hold of them. and yell about them on YouTube about why that was an improperly sustained objection or improperly overruled. Or do you want to object, Mr. Lally? Do you have anything to respond, Mr. Lally, or no? And that was their original motion. And here he goes on to say in this motion, the defendant, law enforcement officers, and potential witnesses have been the subject of intense media interest and scrutiny. Members of the public have engaged in notable activities in conjunction with the prosecution of this case, including private citizens protesting at the courthouse and private citizens engaging in relentless harassment and acts to intimidate witnesses from testifying at trial. Security is a significant concern. The publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry while trial is ongoing, could prejudice the parties and expose jurors to extraneous matters. And that was agreed to by the parties and ordered by Judge Canone. This was the order of impoundment that she initially, sua sponte, ordered with regard to jurors' names, which we went over at length some time ago. That was from July 8th. That was after the trial, after the mistrial was declared on July 1st. And Exhibit 3, and we went over this as well. This was the order with regard to Juror Doe's motion to continue the impoundment order. Where Juror Doe said, well, according to her order, that she found Juror Doe's detailed affidavit to be credible. Juror Doe is in reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. And therefore, she extended the impoundment order with regard to the identities of the jurors until and unless otherwise ordered by the court. But she does go on to say this order shall not preclude any juror from identifying himself or herself and or from speaking to the public about their jury service. So that is document 408. Let's take that down. And go to 409, which is the affidavit in support. Marcello, thank you so much for tuning in from Argentina. Buenas noches. If the Alec Baldwin judge had this case wouldn't be dismissed. She did not put up with any BS. Unlike Bev babysitting Lally the whole time. I think what you mean to say, if the Alec Baldwin judge had this case would be dismissed. Yeah. Thank you, Marcello, for tuning in and for always being so very generous to this channel. Bart Starley, thanks for the 10. Do you think Bev will change her stance regarding allowing the federal investigation being brought up during trial? Let's see what they discover throughout these discovery demands. Let's see what changes. I mean, I am not a betting person. I hate gambling, and I would never, ever bet on what a jury is going to do. And I will never, ever bet on what this judge is going to do. Should she? It depends. If the probative value outweighs the prejudice, that's something that only she can decide through the attorneys remaking that motion, renewing that motion, talking about the confusion that apparently the jurors had with regard to who hired the crash daddies and stuff. So we'll see. I have no idea what she would do, though. Good question. But until motions are made, I can't really opine one way or the other, depending on what they find out through more discovery. Kat, thanks for the deuce. If she denies a motion Is there an appeal process? Well, then, yeah, you can always appeal a motion, but it has to be something final. It can't be something interlocutory. So there's been appeals during this, during the first trial. There was an appeal on a pretrial motion regarding Brian Albert and Jen McCabe's cell phone records that went up to the appellate court and was reversed in part. So yeah, there are certain avenues of appeal. Can you forward an email to DA Marcy? Would you like me to send me something to send to him? Thank you, David. Hannah, I'm still baffled that some of the evidence was even allowed in trial at all. Same here. Like an obviously doctored, inverted Sally Port video that was only turned over during trial with zero authentication. I agree with you. You are not alone. Yuri's math teacher. Thanks for gifting 5 memberships. You're amazing. Thank you so very much. All right. There are over 4,000 of you here right now, and I appreciate each and every one of you so much. Like, you have no idea how much I appreciate you. What would be so awesome is if you would just do like the YouTube courtesy things while we're thinking of it. Like, smash the like button. You could share the stream out. You could hit the subscribe bell because it's free. Make sure you set all notifications so you'll know when I go live, because oftentimes, like today, it's just like a 2-hour, like a little 2-hour window. Sometimes it's a 1-hour window. Sometimes, rarely. But if there's breaking news, I just go on, and you're not going to want to miss it, because the chat here is known as the Snark Tank, and we do have the funniest chat on the internet and the best mods on YouTube. So I'm not afraid to say that either. Here we go. Affidavit of counsel in support of defending Karen Reed's motion for relief from the order of impoundment. David Unetti states the following is true to my best of knowledge and belief. I am an attorney. Somebody sent me something the other day where somebody twitty it about me. Like, is she even really an attorney? Yeah, I am an attorney. Licensed to practice in Massachusetts, not Massachusetts. I'm New York, but he's Massachusetts. And he was retained on January 29th, 2022. That I reviewed the Commonwealth's April 10th, 2024 motion in Lemonade for the appointment of court stenographer, blah, 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 which was allowed by agreement on October 14th. I've reviewed the order of impoundment. I do not contest that you keep the jurors' names impounded. But he says during the first trial in this matter, evidentiary issues were discussed at sidebar. In light of the court's allowance of the Commonwealth's motion on April 14th, 2024, sidebar conferences remain impounded. As the defense has begun preparing for a second trial, currently scheduled to begin on January 27th of 2025, that's important because she has not ruled yet on whether or not the joint motion to push the trial to April Fool's Day is going to be granted or not yet. So we don't know if she's going to do that. And as of right now, it still stands that this trial will commence. We may know more on Wednesday when we do the motions hearing on January 27th, 2025. He says, we've determined that we will need to file motions in Lemonade on a number of evidentiary issues that arose during the first trial. Without access to transcripts of the sidebar conferences, which remain impounded as of this date, we are unable to properly prepare and litigate the anticipated motions in Lemonade. As of now, we are unable to review the court's rationale for its evidentiary rulings due to the order of impoundment. I mean, this is so basic and so obvious that it should just, this is where she should swipe the pen in the margin and just say, granted. As to the sidebar conferences, I believe that good cause exists to release the transcripts of the sidebar conferences from the court's previous order of impoundment, especially since the first trial has concluded. Though it is not the defendant's burden to establish good cause or a change in circumstances justifying the release of documents from an order of impoundment, I nevertheless believe that there is in fact good cause to release the sidebar conferences. I also believe that there is a material change in circumstances. Specifically, the first trial has concluded. In reviewing the case law surrounding relief from orders of impoundment as discussed in the attached motion, I believe that the factors of the court must consider The factors that the court must consider weigh in favor of releasing the sidebar conferences from the order of impoundment. In addition, I also believe that since the first trial has concluded, the Commonwealth's concern that jurors could be exposed to extraneous information is now moot and became moot once those jurors completed their service. I believe that Ms. Reed's right to a fair trial pursuant to the Sixth Amendment will be impeded by the sidebar conferences not being released from the order of impoundment. At a minimum, it is essential that the sidebar conference discussions be released to the parties. Should the court deem it necessary, the defense is willing to sign a protective order regarding these sidebar conferences such that they can be released to the parties of the case. For these reasons, XOXO, signed under the pains and penalties of perjury, our man, David Yannetti. So he's essentially saying to the judge, listen, judge, we really want these released. And you know what? If you have a problem releasing them to the public, because we know you do, kind of, because there's going to be people out there who are going to dissect these and criticize you for your rulings. He doesn't say that. I'm just reading between the lines. We're going to give you the option to just at least unimpound them for the attorneys, because we can't properly prepare for this second trial without the contents of those sidebars, obviously. So, please do that in the interest of fairness and fair trial and justice and all that kind of things and stuff. And he's 100% right. Look at this. Misty Yen Eddie became a new member. I love it. I love it. I love when you guys change your names for the trials. I love it. We still have some old OGs from the Maya trial who have Maya trial names. That was the Kowalski trial. And Misty Yen Eddie, that's amazing. Welcome. Heisenberg, thank you for the 5. There are more high-profile people behind the scenes not supporting her anymore. I don't have any independent knowledge of that. You're saying not supporting Karen anymore. Yeah, I don't know. I don't know what high-profile people you're talking about, but Court TV was never behind her, so there's that. I'm here for it. I'm here for it. John O'Keefe was not hit by a car, and a car did not hit John O'Keefe. There are no injuries to support any motor vehicle PKD. It's called a PKD, pedestrian knockdown. A PKD, that's what we call it for short in the office. Got to go sign up a PKD. Pedestrian knockdown. If there's a personal injury lawyer out there who has ever had a pedestrian knockdown case where there are no injuries below the neck other than dog bites to the arm, I would love to hear about it. Because physics, just physics. Thank you, Romy, for thanking me for keeping you updated. We're not done yet, because this one's really fun. We have document number 412, which is defendant's response to Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. KO bang bang. Let's get this is really funny. This is really funny, Phoebe. So Court TV reached out to me the other night. Was it last night or 2 nights ago? I was unavailable, but they said, Vinny asked me to reach out because we had a cancellation and we really need someone to come on at 9:30 and talk about Karen Reed. Are you available? And I just couldn't do it. It was like they reached out to me at like 8 o'clock. Or I would have. I respect Vinny. I like Vinny a lot. I have been a fan of Vinny since, the 90s when he was covering OJ. Like, that's how long I've liked Vinny. And I respect him a great deal, even though I'm trying to beat him in subscriber counts. So if you guys could just please subscribe. It's secret. He doesn't know anything about this competition that I have, this personal internal competition to beat him in YouTube subscribers. And then when I watched the replay of it, guess who was on? Plevin. So, I mean, if I had accepted that, it would have been a trap. Would have caught in a trap. Yeah, it would have been me and Plevin. But Peter Ellikin, they got Peter Ellikin, who I really like a lot. Peter Ellikin is on a lot. He was on when I was on there with Coffindoffer. a couple of times last January, and he's a good guy, Peter Ellikin, and he deserves all the clients. Like, aside from Misty and Eddie, like, if you need a criminal defense attorney, I would highly recommend Peter Ellikin. He's like smart, he gets it, and he was on with Plevin. They kept him on for the 9:30 half hour, and I was cracking up the next day thinking, wow, imagine if I went on and I had to like debate Plevin. That would have been fun. It would have been fun because it would have been seeing what they talked about. It was no, it was like they needed someone, I guess, on the other side, right? So they needed someone to go up against, I guess, him. And again, they had Peter Elkin stick around because he had been there for the first hour where they were discussing a different case. And I can't remember what case it was because Vinny's show goes from 8 to 10, so it's a 2-hour show. The 9 to 10 hour was the Karen Reed case, and the 8 to 9 hour was, and I don't recall, was it Delphi or was it something different? You want to do a poll on AJ's beard? All right, Stacy, you asked for it, you got it. All right, let's do it. What should the choices be? Oh, you just have to open up the YouTube tab and then go to my own stream. It's like the way that they make you do this is so bizarre. And there's a delay, so it's like a whole thing. All right, let's see. Poll. Oops. I mean, it's not really a full beard, but it's definitely like facial hair. Okay, so the choices are going to be, it's Movember. It's Movember. Thoughts on AJ's beard? Love it. Nope. Shave it. Or meh. Okay, there's your poll. Not that it really matters to him, but you asked for it, so you got it. And go, chat, go. All right. We'll come back to that. And here we are with document 412. Yeah, let's stop about other creators, the side drama. You know me, I like to stay out of it. I'm staying out of any and all side drama. Everyone's entitled to their opinion. I don't tell other people how to run their channels. I don't tell people what time they should be streaming. I don't get mad at people if they schedule a stream before mine is coming. I don't care about any of that stuff. And you guys are better than that. Give me 2 seconds to just get a sip. All right, here we go. This is one that I haven't even had a chance to redline that. Look at us. We're going to redline on the go. And the jury went home on Delphi. Thank you, Aries girl. I usually don't like breaking news in the chat, but I'm very glad that you sent me that. So now we don't have to all sit up on the edge of our seat for verdict watch. But they come back tomorrow because they've had court on Saturdays in Delphi. I don't know what's going to go on there. You know what I think is going to go on there? I think it's a lot like the Karen Reed case in a lot of ways. However, what I think is that just like in the Karen Reed case, people who are on one side can never be convinced to go to the other side, right? If you do not believe that John O'Keefe was hit by a car, nobody is ever going to convince you that he was hit by a car. There's no way. And I feel that same way about Delphi. I feel like there are people who just want to hang Richard Allen, and 100% he's guilty, and 100% he confessed 60 times. And I don't care what kind of conditions he was held in. I don't care that he was tortured in a prison and held in solitary confinement for 6 months before he started with these crazy confessions. And he was psychotic, and he was being forcibly injected with Haldol, and he was eating his own feces and smearing it on his face. And, he was just doing that for attention. And then he started confessing. And even when like his wife was telling him to stop because she knew that she was guilty. No, because she knew that all jail calls are recorded, and she knew that he was psychotic, and he was held in, prisoner of war type Guantanamo conditions for 13 months, like a dog. Like animals are treated better than the way Richard Allen was treated as a pretrial detainee. Like, don't even get me started. And that, he knew about the van, and they completely discount the fact that the psychiatrist or whatever that was Dr. Walla, who was seeing him every day, was a true crime buff who knew all about the Delphi case before she ever started treating Richard Allen, and admitted on the stand that during her daily visits with him, she would discuss with him what people were saying about his case on the internet. Like, it was crazy. The people who are on the other side of that think all the things that I just told you, was like, the guy went in voluntarily to say, yeah, I was at the bridge that day. Nothing connects him. There was no DNA, just on and on and on. People who are on the side of that, as opposed to the other people who are just like, he's totally guilty because he put himself there. He owns a Carhartt jacket, and the blurry image of the bridge guy is definitely him. He definitely was able to kill these 2 girls within 7 minutes, even there no DNA. You'll never change those people. You'll never convince them that they're wrong. So I think it may be a hung jury. I just think that there is going to be people dug into either side. I think there's tons of reasonable doubt, really, which is the only thing they should be concerned about. But I don't think, if there are people that are dug in on either side, I don't think that no matter how much they try, they're going to be able to convince them. And they've been sequestered. They live more than 2 hours away. The jury, they've been in a hotel for this entire time, which really hasn't been that long, because how many weeks has this been going on? Maybe they're on week 3. Yeah, he claimed to have killed his family. He confessed to all kinds of things that didn't happen. So they've been allowed to talk about the case during the trial. Like, that's unusual. That's something that Indiana allows. And it also allows for jury nullification. And there's all kinds of things, that are, every state has its own laws. And it's so interesting because the more cases we cover, the more state laws we learn about. And in Indiana, jury nullification is totally fine. Like, hey, we're going to tell you what the law is, but if you don't if you don't agree with it, just disregard it. Like, you can just, do whatever you want, basically. But the videos that the jury was shown of the conditions that Richard Allen was held in prison and being led around by a leash by prison guards. I mean, despite the fact that they didn't allow any of that stuff in about the other suspects, I don't know, shock. But yeah, not to digress. If the jury went home for the day, that's good, because that means that we can maybe get a verdict tomorrow. Maybe be here for that. So thank you for letting me know. All right, back to Karen Reed. This is the defendant's response to Commonwealth's notice of scheduling reassembly and testing of defendant's Lexus telematics system. Now comes the defendant, Karen Reed, and respectfully files defendant's response to the Commonwealth's notice of scheduling, reassembly, and testing of defendant's Lexus telematics system. As set forth herein, the Commonwealth's new digital forensics expert, Shannon Burgess, remember we looked him up, he called himself a hacker or something, has opined that there were deficiencies in the chip-off procedure conducted by defense expert Maggie Gaffney on the defendant's Lexus infotainment system and telematics system as a result of what he claims may have been programmer's error. As set forth herein, Ms. Reed objects to the Commonwealth's position with regard to the new testing protocol as follows. Oh, I love it. They're like, yeah, no, we're not going to agree to any new testing because, number one, the defendant vehemently disputes Mr. Burgess's characterization of the chip-off procedure conducted by Ms. Gaffney, which is based on Mr. Burgess's fundamental misunderstanding of the difference between a megabit and a megabyte. One of you guys pointed that out in the chat when we went over that motion initially. And I'm just going to say, good on you. They're watching. Both sides are watching. They're watching you. You are the mirror jury, not just in this case, but in every case. And both sides are watching to see what you're thinking. And that was an excellent thought by, I'm sure, one of you. And two, he's probably going to say it was just a typo. And two, Ms. Reed respectfully requests that, a scrivener's error, if you will. Ms. Reed respectfully requests that the court adopt the protocol proposed by defense expert Matthew DeSogra for any future testing of the infotainment and telematics system, which properly accounts for Mr. Burgess's misunderstanding relating to the storage size of the chips in question. That's right. That's right. That's what he did, right? He said there was it was out of storage or something. Well, we'll read more. And seeks to prevent further mistakes by Mr. Burgess, which could result in the unnecessary destruction of evidence. Oops. Statement of facts. On October 11th, 2024, the Commonwealth filed the Commonwealth's Notice of Scheduling, Reassembly, and Testing of the defendant's Lexus infotainment systems, requesting that its new digital forensics expert, Shannon Burgess, be permitted to engage in further potentially destructive testing of Ms. Reed's infotainment and telematics system by conducting a chip-on procedure. Chip on, chip off, chip on, chip off, little grasshopper. Mr. Miyagi. The Commonwealth's request is premised on two opinions offered by Mr. Burgess regarding the analysis of the telematics system and telematics and infotainment system associated with Ms. Reed's vehicle. One, that the evidence acquired in the December 2023 chip-off was incomplete, and there is more data that was not acquired that exists on the chips. And two, that new hardware and software updates have been developed since the chip-off was conducted in December 23, which may assist in interpreting the data. Highly qualified defense expert Matthew DeSogra, a licensed professional engineer and certified IPC specialist with Delta Forensic Engineering, has reviewed the chip-off work conducted by Ms. Gaffney and opines that Mr. Burgess misunderstands certain basic digital forensic concepts, including inter alia, the conversion of megabytes to megabits, negating certain of his opinions and necessitating that certain extra protocols be put in place to prevent programmer error by Mr. Burgess. Footnote 1, which says the curriculum vitae for Mr. DeSogra is attached to Mr. DeSogra's affidavit. As set forth below, Mr. Burgess's incorrect belief that the initial chip-off procedure failed to retrieve all of the data because of programmer error stems from his misunderstanding regarding the storage size of the chips in question. Notwithstanding that fact, Ms. Reed consents to a chip-on procedure for the sole purpose of determining whether any of the updated software or hardware may assist in interpreting the data contained on the components in question. Yes, Martin. Danielson. You know what I'm talking about, right? I don't know if anybody got that because I didn't have the chat open. Danielson. Oh, grasshopper. Oh, grasshopper. Point number 2. Mr. Burgess fundamentally misunderstands the difference between a megabit, and a megabyte. In his declaration, Mr. Burgess incorrectly concludes that the defendant's digital forensics expert, Mag Gaffney, failed to extract all the data from the two modules in the vehicle when she conducted the initial chip-off procedures in December 2023. Mr. Burgess's opinions and conclusions are based on his incorrect belief that the prior chip-off procedure conducted by Ms. Gaffney resulted in 3 files totaling only 8 megabytes in size when they should have been closer to 64 megabytes in size based on the total flash memory component of the chips in question. As explained in the attached declarations of defense expert Matthew DeSagra, Mr. Burgess misunderstands the difference between megabytes and megabits. In point of fact, manufacturing specifications establish that the total flash memory component of the chips in question is equal to 64 megabits. Megabits. It's an M with a small BS. Just a little bit of BS. Not 64 megabytes. Significantly, 64 megabits is equal to 8 megabytes. Thus, Ms. Gaffney successfully acquired 8 megabytes of data from the chips during the December 2023 chip-off, which constitutes the total flash memory component of the chips in question. Converting megabytes to megabits is a basic digital forensics concept, which is critical to successful data acquisition and analysis. Mr. Burgess's failure to properly record the total memory capacity of the components at issue could cause the Commonwealth to seek and perform unnecessary destructive testing, which could in turn result in the unnecessary destruction of evidence. Accordingly, as set forth below, the defense respectfully requests that a defense expert be permitted to be present during any future testing conducted by the Commonwealth, and that the defense expert be permitted to halt any testing and seek court intervention if Mr. Burgess makes any future mistakes which risk compromising the data at issue. I mean, this is what you call major egg on face. Sadly, not only for Mr. Burgess, but for the Commonwealth who hired him and relied on his expert opinion, which is, if all this is true, because I'm not a biomechanical engineer by any stretch, nor do I understand the basic digital forensic concept here, but apparently an expert should. Point number 3. This is kind of like basic crash reconstruction stuff and things that Trooper Paul didn't know about, because wasn't he asked about, oh my gosh, I loved it. AJ's cross of Trooper Paul was fire. It was fire. Do you remember when he said to him, like, he asked him a question and I can't remember exactly what it was. And he's like, what is like, I can't remember what it was. What is the basic thing? Olivia, maybe I see that you're here. What's the basic equation for velocity or something like that? And the answer, what is velocity, right? Was that it? What is velocity? I knew it had to do with velocity, and he couldn't answer the question. He's like, well, it's kind of like has to do with something as such, speed, and like he had no idea, like basic stuff. Ozzy's not an expert, and she called it out and tagged you, Nettie. Ozzy, you seem like an expert. The stuff that you do, if you guys are not following Ozzy Insider, even though we may disagree on the Delphi case, I still love you, girl. The videos that you do on like technical stuff, you make it really easy for people to understand. I thought you were like a technical wizard. So you really understand it and you explain it in a way that other people can understand it. So maybe they're watching. It is so embarrassing for them. Jonathan Rubin. Burgess's career is pretty much in the crapper now. Have you seen his LinkedIn profile? He likes to reverse engineer things. Pirouette. What is kinematics, right? What is kinematics? What is velocity? He was referred by Jessica Hyde. That is true. The laws of kinetics, basic things that Trooper Paul. It just did. Chloe Albert's revenge. It just did. Evidence just revealed itself. And, why is that? It just did. Key cycles are going to be an issue. Can't wait for them to clap back on that, on the key cycle issue. Okay, here we go. Point number 3. Defendants proposed amendments to the Commonwealth's proposed protocol regarding the examination of the infotainment and telematics system. New and updated Burla software, which did not exist at the time Ms. Gaffney conducted the initial chip-off procedure in December of 2023, could potentially assist in decoding additional information from the Lexus infotainment and telematics system at issue. As a result, Ms. Reed requests that the Commonwealth be permitted to conduct further testing with oversight by a defense expert. They're like, yeah, bring it on. Because now that Burla has this software, let's go. Because you know what? That data is going to exonerate her. So let's do it. Except for somebody needs to babysit for Mr. Burgess because he clearly doesn't know what he's talking about. Our expert's better than your expert. That's what this is. But they're like, bring it on. Yeah, we want to test it too. Remember Garino's testimony? Because we went over that one day when we went over, I think it's when we went over the original motion of the Commonwealth to do this retesting. And Garino had the audacity to say that, well, you know, I went to like a sales conference and I went over to the Burla table and I kept asking them, like, you know, when are you going to have the right software for the Lexus and stuff like that? And, you know, they were like, you know, call the helpline. So, you know, kind of followed up on it, called the helpline. That was embarrassing too. The first step of any acquisition protocol is to properly record inter alia. For those of you who would like your daily Latin lesson, inter alia means among other things. The memory storage capacity of the components the expert intends to test. The Commonwealth's expert failed to do that here. As explained in the affidavit of defense computer forensic expert Matthew DeSogra, which is filed herewith throughout Mr. Burgess's infotainment data acquisition protocol, Mr. Burgess incorrectly reports the total memory storage of the components at issue. Ms. Reed respectfully requests that Mr. Burgess's proposed infotainment data acquisition protocol be updated as follows to prevent any programmer error during future testing. And then they set forth all of these really technical things, which I'm not going to read here because we're going to go to his affidavit and read it there. Let's hear it from the expert's mouth, because this is basically what he says, and we will go over it over there about spansion, megabits, flash memory, and things like that that are very technical. Additionally, Mr. Burgess proposes that he perform an additional chip-off acquisition attempts to ensure complete data capture. This step is unnecessary because all available data was successfully retrieved during the first acquisition. In other words, the file size of the acquisition already matches the expected memory storage capacity of the components. However, as explained by Mr. DeSogra, Mr. Burgess should conduct an acquisition to ensure that the contents of the memory chips have not been altered by confirming the checksum of the chips in advance of any further testing. It's like basically like, hey, Burgess, do you even know what this means? Even know what this means, guy? An alternative proposed protocol for the examination of the infotainment and telematics system, which was prepared by defense expert Matthew DeSogra, a licensed professional engineer and certified IPC specialist, is filed herewith. As set forth in the protocol proposed by Mr. DeSogra, the defense respectfully requests that the defense expert be permitted to be present during any future testing and to temporarily halt any testing if Mr. Burgess attempts to engage in any testing which risks unnecessarily compromising the data at issue, such that the defense may seek court intervention. They'll be like, yeah, hold the phone, get your solder tool, whatever you call that thing, away from the motherboard, and we're going to call the judge to make you stop. Conclusion for the foregoing reasons, basically that the Commonwealth expert is a nudnik. We request that this court adopt the proposed protocol. XOXO. Ellen Jackson, Elizabeth Little, and Misty and Eddie. Alan Jackson's specialty, among many other things, is forensics. Cellular and other forensics. That's what he's known for. I believe that's how he was able to exonerate Kevin Spacey, based on cellular forensics. And that's his jam. And so you notice that he's the lead signature on this motion. Ms. Dianetti was on the other. Here's Exhibit 1. Here is the curriculum vitae of Matthew Di Sogra of Delta Forensic Engineering in Charlotte, North Carolina. He has his BS in mechanical engineering from UNC Charlotte in 2011, and in 2013 he received his Master's of Science in Mechanical Engineering from the same university. He's a licensed professional engineer in North Carolina and a certified IPC specialist. From November 16 to present, he's a professional engineer with Delta Forensic Engineering, not to be confused with the airline, specializing in motor vehicle accident reconstruction and vehicle system analysis. Accident reconstruction includes analysis of collision dynamics, vehicle speeds, collision avoidance, collision simulations, event data recorders, and advanced data recovery methods. Before that, right after he got his master's, he was an associate engineer with the same company. And he was also an intern at one time with General Dynamics. He's done also a lot of continuing ed. Event data recorder summits, conferences, and all kinds of things that have exactly to do with the topic at hand. And he's published. He's published many articles, 1, 2, 3, including one entitled Chip and Board Level Digital Forensics. This is his wheelhouse, and he's done presentations on it as well. Especially this one. Chip level data recovery, understanding the techniques, in 2020 at the NAPARS Joint Conference, whatever that is, in Charlotte. Yeah, I'd say he's qualified just from a cursory review of his credentials. Go to the chat before we go to his affidavit. As always, your thoughts and comments are welcome. Look at all these new members. New members, welcome. Welcome, Kelly. Welcome, Sandy Piv. Welcome to Jenna Peterson. Welcome to GFY. I love it. Oh, and I like the Rolling Stones. It looks like a Rolling Stones shirt in your profile pic. Nice. Trooper Paul just did, said Chloe Albert's Revenge. I think I highlighted that one already. Chloe Albert's Revenge, thanks for the 5. Trooper Paul was not real. Haven't you noticed his resemblance to 3 crash test dummies from those old commercials? God, I feel bad for him. I feel like he was just really just thrown under the bus. I think he was thrown under the bus. They gave him a set of facts and they're like, okay, reverse engineer something. And I kind of feel like he thought he really did it right. He thought he was going to be like the star witness of the trial. And it turned out so the opposite. And he's become kind of a, laughingstock of the trial. I feel bad for the man in a way. I don't know. That's my empathy of the day. That's all you're going to get. Thank you, David Reese. Oh, David, this is yours. He says, evidently, they got a guy from Finland who had tweeted that Paul was wrong about the key cycles of his testing. Yeah, we went over that during, I think, one of the last shows that I did. Because they exchanged, the Commonwealth exchanged an email from this guy from Finland, and I forget his name. It escapes me. But just because they exchanged the email that they got from him doesn't mean that they've hired him. It just shows me that Brennan is exchanging under his obligation all of the things that they have in their possession that could be exculpatory to the defense. Because if I remember correctly, that those tweets, weren't they anti Trooper Paul's theory? Yeah, anti, right. So the Commonwealth exchanged that email with the defense just in case the defense didn't have a copy of it, saying, hey, listen, we know our obligations and we're turning this over to you because this could be exculpatory. Thank you for pointing that out. All right, moving on to the affidavit of this new expert. Which is here, document number 413. Don't forget we have a poll up. Does everybody have the poll up? Oops. So far, we've got about AJ's beard. 56% love it, 20% say shave it, and 24% you don't really care. You're like, meh. Meh. Breaking news, my friends, breaking news. Disgraced Hollywood producer Harvey Weinstein is back in the hospital after his cancer diagnosis and plans to sue New York City over medical negligence. Well, good luck with that, Harvey, because karma has your address too. Okay, back to the docs. Please vote if you would not like to vote. We only have 1,442 votes so far out of over 4,000 of you that are here. So the Lovitz are winning. You're winning so far. Stacey Q, you asked for it, you got it, and so far you're winning. Not that he's going to see this or even care, but gives us something fun to do while we're snarking. Here's the affidavit of the defense expert, defense computer forensics expert, Matthew DeSogra, in support of this motion. Can I show a photo? Let me see if I can find one. when I Google Alan Jackson beard, it comes up with, I guess there's a country singer named Alan Jackson also. Hold on. Yeah, I'm not seeing one. We saw it when he was in court on the appeal. And we kind of like zoomed in on it then. Search Alan. I did, but I'm not getting any beard pictures right now. If anybody has it, you can just shoot it to me. Shoot me a picture. Fanbase at mlittlelaw.com. That'll be quicker than me trying to find it. Thanks. Appreciate you as always, my friends. I, Matthew DeSogra, under oath, do depose and state as follows. I am super duper qualified. No. I am a licensed professional engineer in North Carolina and certified IPC specialist. I currently work as a professional engineer with Delta Forensic Engineering and specialize in chip and board level digital forensics. Copy of my CV is attached here too. We just looked at that. The following facts and information are based on my own personal knowledge, and I could testify competently thereto if called upon as an expert witness to do so. I declare that the following is true and correct to the best of my knowledge. I have reviewed the Commonwealth's notice of scheduling reassembly and testing of defendant's Lexus telematics system and proposed protocol prepared by Mr. Shannon Burgess. Certain statements set forth in Mr. Burgess's proposed protocol, which form the basis of his opinions, are factually inaccurate. Oops. In his analysis, Mr. Burgess misstates the memory storage capacity of the chips in question by failing to account for the difference between a megabyte, megabit, gigabyte, and gigabit. Conversion between and among these units is a foundational digital forensics concept which necessarily impacts data acquisition protocols and analyses thereof. Thanks, little cupcake, for coming in hot with the pick. I got it. Let's go to the picture so that you guys can take a look. It's a screenshot, so it's a little bit blurry, but there it is for those of you who want to vote on how you feel about the beard of Alan Jackson. Smooth as butter. There it is. See, we're here for you. Little cupcake. Everybody thank little cupcake. Now you have the opportunity to decide. Do you love it? Is it like meh? Or is it no, get rid of it, shave it? I don't care about no shave Movember. Okay, back to the document. I personally obtained and reviewed the manufacturing specifications of the chips at issue in this case. Mr. Burgess misstates the memory storage capacity of the chips, which were removed from Ms. Reed's Lexus infotainment and telematics system as follows. A. The Spansion 99JL064J001 is a 64 megabit flash memory component, not a 64 megabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 64 megabits is equal to 8 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. B. The Micron JWB57 is a 4 gigabits flash memory component, not a 4 gigabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 4 gigabits is equal to 500 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. C. The Micron 29F2G08ABAEA is a 2 gigabit flash memory component, not a 2 gigabyte flash memory component, as Mr. Burgess incorrectly states. Notably, 2 gigabits is equal to 250 megabytes, which suggests that all available data was successfully retrieved during the first acquisition. Based on the above, I suggest that Mr. Burgess's proposed protocol be amended as follows. A. Step 1 of Mr. Burgess's proposed protocol, labeled Reattempt Chip-Off Acquisition, is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components. However, an acquisition may be conducted for the sole purpose of ensuring the content of the memory chips have not been altered since the last testing by recording the checksum of the chips in advance of any new testing. Wouldn't that be interesting? Wouldn't that be interesting if our new Italian friend, Matthew Di Sogra, comes in and does this acquisition of the memory chips to find out if this stuff that has been in the possession of the Commonwealth since the car was seized on January 29th of 22 was altered, or stuff was deleted. Huh. That would be insane. I mean, the inverted video wasn't enough. That would be insane. B, defendant's experts shall be permitted to be present during any future testing or data acquisition conducted by the Commonwealth and or its experts. C, defendant's expert shall be permitted to immediately halt any testing that I deem places the data at issue to prevent the unnecessary destruction of data until such time as the defense can be heard before this court. XOXO, Matthew Di Sogra. Well, there's that. He seems awfully qualified to me. And it seems like he's going to be able to put to rest any possible shenanigans. And they're saying here, the defense is saying, let's do it. Let's do it. Absolutely. Let's go back. Let's rechip it, put it back on the motherboard, resolder it, whatever you got to do. And let's make sure nothing's been altered, nothing's been changed, nothing's been deleted. Because based on the new Burla software, thank you, Team Brittany, coming in with another hot photo of Alan Jackson. I don't mean like hot photo, like he's hot, but I mean, you can draw your own conclusions on that. I'm just saying hot off the press. So there's that here. Let's see. May this aid you in your decision, and may the odds be ever in your favor. The defense team is not opposing additional analysis of the motherboard of Karen's Lexus. They're like, yeah, let's do it. Let's do it. Because based on this software, we're confident that either it's going to exonerate our client, or we're confident that it's going to show that somebody over there in your Sallyport may have deleted, altered, or done something with the data in there based on the fact that your guy doesn't even know the difference between a megabyte and a megabit. And he absolutely should. So there's that. Yeah. Oh, yes. Right. That's right. This is the man that I was, everyone thought not everyone, but some idiots thought that I went to Cancun with. We saw Dave Matthews together. I don't even know if he likes Dave Matthews, but that was a rumor out there. When Grant went up to Alan Jackson I don't think it was during the trial. He thought he was getting a real scoop. He had the opportunity to ask a question of one of the greatest trial lawyers of our time, one of the best and most renowned trial lawyers in the country, who is one of the defense attorneys in one of the cases of our century, the Karen Reed case. And what Grant Smith Ellis chose to ask Alan Jackson, there's video of it somewhere, is, Mr. Jackson, did you have a good time with Melanie Little in Mexico? Twice. And then he chased him up the stairs and asked him that again. It was bizarre. JD, y'all better donate to Karen's Defense Fund. AJ needs some razors. No, this is current. This is Team Brittany put this in chat. Team Brittany, this is current? It does make him look younger, right? I think it does. Magnolia Gypsy Defense is like, let's go, LFG. But make sure it's done by someone who knows what the heck they're doing. Yeah, what the duck? If you know, you know. Thanks for the 5. Love listening to you. Busy cooking fresh Portuguese cheese as I watch you. You're making Portuguese cheese? That sounds delicious. Life of Touché. Thanks for the deuce. Bev want to bring in harassment in the case? Good. Kay Willis, Realtor, welcome. Thanks for becoming a member. Hannah Crum, do you think that Bev will harp on AJ because she knows his tricks now? I think there's a lot of tricks up his sleeve that we haven't even seen yet. I think she's going to harp on him no matter what, because it's a privilege, Mr. Jackson. It's a privilege for you to be in this courtroom. It's a privilege for you to be practicing in Massachusetts. That's not the way we do it in Massachusetts, Mr. Jackson. Stacy, thanks for becoming a member. Hannah, will the federal case be finished by the second Karen Reed trial? I have no idea what the status of their investigation is, so I have no idea. I have no insider knowledge to that. I don't know what they're investigating. I don't know what they're looking at. I just don't know. If you know, you know. Someone please explain how before they could not get any data because it was destroyed, but now it's not. It makes no sense. I think they're saying that the proper software didn't exist because Garino said, he kept asking Burla when they were going to invent the proper software. And so he had to, pull the whole thing out, and he had to destroy it, and he had to chip off the motherboard. And then we found out that in the Brian Walsh case, oh no, it was the Rich Schiffer case. Richard Schiffer, the guy who's being accused and prosecuted for the rubber ducks, that they went to his place of employment with a thing that they just stuck into his Toyota truck, got all the information out of it, and left. And they did the same thing. I think it was Brian Walsh with his Volvo. That I may be conflating my cases, but I think in Brian Walsh, I know Proctor was the one who wrote that affidavit to get the information off of Walsh's Volvo. And I know that I think it may have been even made that he could sneak into the garage of Walsh and get that stuff off the Volvo surreptitiously. And that's what he did. They didn't need to disassemble the whole entire thing. And it's also, it's important to note that Toyota and Lexus are made by the same manufacturer. So yeah, I can't explain that to you, but maybe somebody with more forensic smarts than I can. If you know, you know. Thanks for another 10. So let's go back to the basics. If per Proctor had taken a picture of Karen Reed's taillight when her car was impounded, we wouldn't be here right now, but he didn't. So it smells to high heaven. Yeah. Exactly. Not to mention that all the witnesses say that it was cracked. They said it was cracked. Nobody said it was shattered. Even Carrie Roberts said there was just a little tiny piece missing. But again, both attorneys, both sides were only given 1 hour for closings, which is insane. I will tell you that in the Delphi trial, both attorneys were allowed to have 2.5 hours each for closing. They didn't use it all, but they were allotted that. I will point out that in Sarah Boone, which is only a 6-day trial, maybe 5.5 days all told, they were each allotted an hour and a half for closings. That 1 hour was not enough in a case that lasted 9 weeks. Come on, man. That's just ridiculous. Absolutely ridiculous. I wanted to pull up the exhibits on one of those motions because I know that I have them. They were just not in that document that I pulled up for you. So give me a second to just find it. I have them somewhere. Fear not, my friends, fear not. Oops. Come on, man. I thought I did. Maybe I don't have it. It's 408. It's the exhibits attached to 410. And I thought I had it, but maybe I don't. Maybe I was just imagining things. Quite possible. That was the one that attached the email from Marcy to the judges, but it's okay. We've already seen it before. I'm not going to waste time looking for it. All right. Thoughts, questions, concerns, comments. See where we stand on our poll. If you know, you know, says with a $5 super chat, fresh Portuguese cheese is so easy to make. If you want the recipe, let me know. Fresh brown. That's lovely. That would be lovely. Sure. Anna says I'm Portuguese and we have the best cheese. I believe it. I absolutely believe it. All right, I'm going to end the poll. Get your votes in now. Get your votes in now. And here's how we stand right now. The beard, love it, 54%. Shave it, 21%. Meh, 25%. So look at this, getting in here. Final votes going going, gone. 54% of you love it. So that's interesting. 24, meh. Nope, shave it, 20. All right, my friends, final thoughts before we wrap, aside from thanking the moderators for keeping it classy in here, as always, and one of the best places on the internet to be. We'll see what happens with these things. We'll be back here on Wednesday to cover the motions hearing. I'm sure that I will see you at some point this weekend for something. Maybe there will be a verdict on Delphi tomorrow. Who's live now that we should raid? Let me take a look. Do a cupcake raid over to somebody, because that's what we do here. That's the nice thing to do. Let me take a look. One minute. Hold, please. Thoughts? Who's live right now? I was going to send you to somebody who's doing Delphi, but I don't see anybody on right now. All right. It is what it is, my friends. I'll probably see you before the weekend's out. So please do the YouTube-ish type things. YouTube courtesy, smash the like, share the stream out, hit the bell so you get all notifications. Make sure you have notifications on your phone enabled so that you get the notifications. And as you know, as I always say, let's thank the moderators, because they are the best. They are the best. You want to go to Young Jerks? Okay, I could do that. Tell him I sent you. Tell Mike I said hi. Let's see. It's not coming up. Why is it not coming up? No, it says upcoming. It's not coming. It's not live right now. Okay. Be cool, be kind, be classy, all the things. I'm tired. I got to go take a nap. All right, you guys, peace out. I'll see you real soon. Thanks for hanging out with me today. Good night.